So I heard back from the federal court on my case against the tribal police and tribal council, and I'm really happy to tell you that they're going to allow me to move forward on 8 of my charges against them, and I'm very happy about that. This is particularly amusing. Okay, so people, they don't like to read, so I'll read it to you. Before the court are 4 motions. Plaintiff Shelley Lynn Hokanson filed 3 motions: a notice of Scrivener's error and the motion to correct the docket, electronic court file number 29, and notice to the court of clerical error and motion to correct the record, electronic court file numbers 30 and 31. The final motion was filed by defendant Fallon Paiute Shoshone Tribe Business Council, the quote, Tribal Business Council, end quote, on behalf of the remaining defendants, seeking the court find Hokanson to be a vexatious litigant pursuant 28 United States Code 1651 and to impose sanctions under 28 United States Code subsection 1923, electronic court file number 39. For the reasons stated below, Hokanson's notice of Scrivener's error and motion to correct the docket, electronic court file number 29, is denied as moot. Hokanson's notice to the court of clerical error and motion to correct the record, electronic court file numbers 30 and 31, is granted. And the council's motion to find Hokanson a vexatious litigant, electronic court file number 39, is denied. Woo woo. And I bet you he thought I was going to be so intimidated by that. That he's trying to have me declared vexatious and get sanctions against me. This guy should know better. He's a trained attorney. I'm a freaking 8th grader. Anyway. The court will first address the motions filed by Hokanson. Hokanson's first request to correct the docket seeks the court amend the docket entry for her 3rd amended complaint, TAC, electronic court file number 29. In the motion, Hokanson states defendant Juarez was not listed in the docket text as defendant named in the 3rd amended complaint, and therefore seeks to have Juarez's name added to the docket entry. However, the docket entry now lists Shasta Juarez as the first defendant, electronic court file number 27. The text for the 3rd amended complaint's docket entry now reads in full: 3rd amended complaint, jury demand against Shasta Juarez, David Blackeye, Edwin Conway, Christina Dalton, Lynette Fisherman, Robert Griggs, Andrew Hicks, Philip Johnson, Vicky Moyle, Barry Starks, Kathy Tooney, Kay Ward, and by Shelley Lynn Hokanson, removes parties attached number 1 civil cover sheet DLS, modified 10/6/2025 to add party DLS, entered 10/6/2025, electronic court file number 27, emphasis added. The notes in the docket text show that the entry was modified on October 6, 2025, the same day the 3rd amended complaint was filed, to add a party. From this, the court infers that the court clerk recognized that Juarez was omitted from the entry and edited the entry to add her name. Juarez's name is thus currently listed on the docket entry, and consequently, Hokanson's first motion to correct the document ECF 29 is denied as moot. As to the second request, Hokanson asks the court to correct the record to show that she filed her 3rd amended complaint before filing her motion for temporary restraining order, electronic court file number 25, and preliminary injunction, electronic court number file number 26, electronic court file numbers 30 and 31. Hokanson states that because 3rd amended complaint was filed after the motions for injunctive relief, the incorrect sequence creates confusion in the record because the motions are predicated on the claims in the 3rd amended complaint. Hokanson asked the court to correct the docket, or, in the alternative, officially note for the record the timeline of submission and filing. The notice to the court of clerical error and request for correction of the record, electronic court file numbers 30 and 31, is granted to the extent that the court notes that the 3rd amended complaint was submitted to the court before the motions for injunctive relief, although third amended complaint appears on the docket after the motions for injunctive relief. 2. Tribal Business Council's motion. The court now turns to the Tribal Business Council's motion for the court to find Hokanson to be a vexatious litigant under 28 United States Code, subsection 1651, including issuing a pre-filing injunction and to impose sanctions under 28 United States Code, subsection 1927, electronic court file number 39. Hokanson opposed the motion, electronic court file number 40, and the council did not reply. I guess it was untenable. The court will first address whether Hokanson should be deemed a vexatious litigant before turning to whether sanctions are available under 28 United States Code, subsection 1927. Vexatious litigant. The district court has the inherent power to enter pre-filing orders against vexatious litigants. Molsky v. Evergreen Dynasty Corp. 500. So it's right there. There, you can read that, okay? 9th Circuit 2007, citing 28 United States Code 1651A. Because a pre-filing order implicates a litigant's right to access of the court should enter such an extreme remedy, quote, only after a cautious review of the pertinent circumstances, end quote. Prior to entering a pre-filing order, the court must give the litigant notice and an opportunity to be heard, citing DeLong v. Hennessy. The court must set forth an adequate record for review to make, quote, substantive findings about the frivolous or harassing nature of the plaintiff's litigation, end quote. Quote, an adequate record for review should include a listing of all the cases and motions that led the district court to conclude that a vexatious litigant order was needed, end quote. At 1059, quoting DeLong 912 F2D at 1147, flagrant abuse of the judicial process cannot be tolerated because it enables one person to preempt the use of judicial time that properly could be used to consider the meritorious claims of other litigants. DeLong 912 F2D at 1148. To determine whether the litigant's conduct is frivolous or harassing, the court evaluates, quote, both the number of and content of the filings as indicia, I don't know how to pronounce that, of the frivolousness of the litigant's claims, end quote. Quotation admitted. Litigiousness alone is not enough either. The plaintiff's claims must not only be numerous, but also be patently without merit. Ringgold, Lockhart v. County of Los Angeles, 761 F3D, 1057, 1064. Quoting Molsky, 500 F3D at 1059, internal quotations and citations omitted. Finally, a pre-filing order must be narrowly tailored to closely fit the specific vice encountered. DeLong 912 F2D at 1148, quotation omitted. A pre-filing order is overbroad if it prevents the litigant from filing any suit in the court or applies to a suit against anyone when the record showed the plaintiff was litigious with respect to only one group of defendants. ID at 1061. Whether to enter a pre-filing order against a vexatious litigant lies within the court's discretion. At 1056, when district courts seek to impose pre-filing restrictions, they must, 1, give litigants notice an opportunity to oppose the order before it is entered, 2, compile an adequate record for appellate review, including, quote, a listing of all the cases and motions that led to the district court to conclude that a vexatious litigant order was needed, end quote, 3, make substantive findings of frivolousness or harassment, and 4, tailor the order narrowly so as to, quote, closely fit the specific vice encountered, end quote. ID at 1143 or 1147 through 46. No, 48, I can't see. To support their request to find Hokanson's a vexatious litigant, The Tribal Business Council points to Hokinson's numerous filings on the docket, including her multiple attempts to file a sufficient complaint, electronic court file number 39. The council also points to the multiple extensions of time Hokinson has been granted to refile her complaints, and the fact that Hokinson has objected to reports and recommendations issued in this case. In opposition, Hokinson argues her filings are not vexatious, but rather are, quote, good faith attempts by a citizen without legal counsel to navigate federal procedure and hold officials accountable for their actions, end quote. Electronic court file number 40 at 2. Hokinson also points out that she has filed multiple complaints in this case because she was following the court's instruction to do so. Based on the record before the court, the council is seeking that Hokinson be deemed a vexatious litigant based solely on the instant cases. As an initial matter, a single case is far fewer than what other courts have found, quote, inordinate, end quote. Ringgold, Lockhart, 761 F3D at 1064 through 65, collecting cases. In Ringgold, Lockhart, the Ninth Circuit explained that whether a litigant's motions practice in two cases could ever be so vexatious as to justify imposing a pre-filing order against a person, we do not now decide. Such a situation would at least be extremely unusual in light of the alternative remedies available to district judges to control litigants' behavior in individual cases. ID at 1065. In reviewing Hokinson's motion practice in the instant case, her conduct does not reach the level of the, quote, extremely unusual, end quote, situation described by the Ninth Circuit. While Hokinson has submitted numerous filings in the docket, that in and of itself does not amount to, quote, flagrant abuse of the judicial system, end quote, DeLong 912 F2D at 1148. Additionally, as to Hokinson's filing of multiple amended complaints, the court expressly gave her leave to do so. See electronic court file numbers 6, 14, and 24. It would be nonsensical to find a plaintiff to be vexatious based partially on her filings of amended complaints with leave of the court to do so. The same is true for Hokinson's objections to the court's report and recommendations, which are expressly allowed by 28 United States Code 63B1C and Rule LB 3 through 2 of the local rules of practice. Further, as indicated in the court's report and recommendation screening Hokinson's third amended complaint, the undersigned recommends that Hokinson be allowed to proceed on 8 claims. Electronic court file number 41. Thus, the court cannot determine at this juncture that her claims are, quote, patently without merit, end quote, Ringgold, Lockhart, 761 F3D at 1064. Therefore, the record before this court is inadequate to support a finding that Hokinson is a vexatious litigant and for the entry of a pre-filing order, and the court will not exercise its inherent authority. The Tribal Business Council's motion, electronic court file number 39, is therefore denied as to the request to deem Hokinson a vexatious litigant. Sanctions. Under 28 United States Code subsection 1927, the Tribal Business Council next seeks the imposition of sanctions against Hokinson under 28 United States Code subsection 1927, electronic court file number 39. 28 United States Code subsection 1927 states the following: any attorney or other person admitted to conduct cases in any court of the United States or any territory thereof whoso multiplies the proceedings in any case unreasonably and vexatiously may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. The Ninth Circuit has held that Section 1927 sanctions may be imposed upon pro se plaintiffs' wages v. IRS 915 F2D 1230, 1235, Ninth Circuit 1990. Accord Harrow v. Hornbrook Community Services District 778 Fed Approx APPX. I need to know what those things mean, don't I? 472 The Ninth Circuit 2019, citing wages in support of affirming award of sanctions under 1927 against pro se litigant. However, in this case, there is not sufficient conduct to find that Hokanson has multiplied the proceedings in the case unreasonably and vexatiously. Other than the instant motion, defendants have not been required to expend resources defending this case because the court previously dismissed Hokanson's complaints without ordering service. Based on the lack of evidence provided in support of this motion, the Tribal Business Council itself appears to have made an unreasonable filing. Yeah, boy, and they're trained attorneys, so shame on you. The court therefore also denies the Tribal Business Council's motion as to the request for sanctions. Conclusion. It is therefore ordered that Hokanson's notice of Scrivener's error and request to correct the docket is denied as moot. It is further ordered that Hokanson's notice to the Court of Clerical Error and request to correct the docket, electronic court files numbers 30 and 31, is granted. And it is further ordered that the Tribal Business Council's motion to deem Hokanson a vexatious litigant and for sanctions, electronic court file number 39, is denied. November 17, 2025. So, how about that, huh? Pretty good. And then I got this cool little doodah I've been working on here. Where did it go? Here it is. Here's my response. Here's my cross motion. It's not all dinged out yet, but it's pretty well ready to go. And so what I'm going to do, I'm not really asking for monetary sanctions. What I'm going to do is ask the court to send those lawyers back to school. Would that be embarrassing? Yeah. I just really want these people to get a clue that I'm not as dumb as I look. And where I'm dumb, I've been educated well enough to figure out where I can find out how to handle it. So, let's get her done, huh? All right. If you made it this far watching, thank you so much. I love you guys. All thousands and thousands of you. You're the best.